Take the recent conviction of several individuals on fraud charges in Florida arising out of the construction of the airport terminal. Here, we are still at the preliminary stage, while the entire judicial process has been completed in the United States. The primary purpose, if not the sole purpose, of an inquiry is to determine whether a prima facie case has been made out. It is not for the purpose of chalking up as many inconsistencies or contradictions as possible for use at the ultimate trial. Sadly, we have lost sight of the real purpose, with the result that much judicial and public time and expense are wasted. It is time to embark on a more expeditious procedure to break the gridlock that prevails in our system. It requires no rocket science to change the system into one that serves the administration of justice in a more purposeful way. A simpler and a more acceptable system would be to provide that when accused persons appear before the magistrate on the first occasion, a decision is made whether the matter will proceed indictably or summarily. If indictably, the question of bail is settled and the matter is immediately transferred to a High Court judge. At the first hearing before the judge, an opportunity can be given to the accused to show that there is no case to answer. This is done by way of written submissions. If cross-examination is required, it is also done by written submissions. The judge will decide both issues. If not persuaded, the judge will advance the case to the next stage, the case management stage. Here, directions can be given for the obtaining of witness statements and other investigations within a permitted time limit. At a further stage, directions pertaining to disclosure and exchange can be made, and yet another, the determination of the salient issues to be tried. This can be achieved within a framework of specific case management rules. With a criminal system that is properly structured to manage cases effectively and efficiently through the courts, we will find that witnesses will no longer be exposed to the criminal element for any considerable length of time. Justices of the peace will no longer have to testify, and the need for voir dire at almost every trial will be reduced considerably, if not completely eliminated. There will no longer be trial by ambush, and a measure of confidence will be restored by the introduction of properly structured system that is geared for efficient use of judicial time. In the magistracy, a similar form of management rules can be introduced. We must, however, first rid these courts of a multitude of matters that do not necessarily have to be processed in the magistrate's court. Last year, I made mention of the ticket cases that clog the traffic courts. To date, nothing has been done. The traffic courts continue to be plagued by some 100 to 120 cases each day. Out of the 22,000 ticket cases received in the courts every year, all ticket cases are sent to the magistrate's court. Some 50% of the fines are paid either before or after hearing before a magistrate. The other 50% remains in the system as unpaid until warrants can be enforced. That represents a loss of immediate revenue in the sum of $8 to $9 million a year. Collection of fines is an administrative function, not a judicial one. By freeing up the judicial system of this task, judicial time can be better spent on dealing with more pressing criminal matters.